You opened that bottle.
Yes, ma'am.
That bottle was sealed before you opened it.
Yes, ma'am.
And so you twisted the top of the bottle
Yes, ma'am.
and you broke the seal.
Yes, ma'am.
And after you opened it, you dumped out the contents.
Yes, ma'am.
You dumped it onto the road.
Yes, ma'am.
Then you put the top back onto the bottle.
Yes.
And then you put the bottle back into the car.
Yes, ma'am.
You threw it on the passenger side.
I did.
And has that always been your testimony?
Everything that you just asked. I did not know that I opened the bottle in my original testimony.
At a pretrial hearing, you swore to tell the truth, correct?
Yes, ma'am.
And you testified that you didn't unseal it.
Objection, Your Honor.
Overruled.
Yes.
So, at that time, that was a lie.
Unknowingly, yes.
So, Your Honor, I would agree with counsel's argument. However, I would say that at least the state could have still proven under 32203 that as the lesser of the DWLS, the defendant's license was not valid at the time, and therefore we should still be able to go forward on at least that charge.
On a no valid driver's license charge,
Correct.
I'm going to grant the judgment of acquittal based on the statutory provisions and the fact that this was a suspension for financial responsibility. I'll grant the JOA as to count 2.
On May 7th, 2023, just after 2 in the morning, Tallahassee police officer Kirsten Oliver pulled a white Mercedes off Monroe Street. The driver was Calvin Riley Sr. His headlights were off, his license was suspended. What happens next is why this case went national. Oliver searches Riley's car and finds a full sealed bottle of vodka wedged behind the driver's seat. Her own body camera is still recording. You will hear the seal break. You will watch her pour part of it out, cap it, and put it back, and then tell the other officers on scene that she found it open. Nearly a year later, in a sworn deposition, Oliver is handed her own body camera footage and asked, under oath, whether her earlier testimony, that the bottle was already open, had been true. It hadn't. That deposition leaked. Local outlet. Our Tallahassee published it under a headline that named exactly what the footage showed: an officer planting evidence. On April 5th, 2024, Calvin Riley's case went to trial in Leon County Court before Judge Jason Jones. Before a jury was ever sworn, his defense attorney stood up and asked the court to throw the entire case out, arguing that police had manufactured the very evidence being used against her client. The judge disagreed. He sent it to the jury instead. What 12 strangers were about to hear was an officer explain on the stand how she came to unseal a bottle that should have proven nothing at all, and whether a mistake once made on camera gets to unhappen just because she didn't mean it.
Is the reason why you slowed me down?
Yes, sir. So you don't have any headlights on, and you're going really fast down Monroe Street.
Headlight? My headlights automatically on when I'm driving.
They're not on right now.
Are you sure about that?
Yes, sir.
Okay. No problem.
Mr. Riley, I got a quick question for you.
No problem.
So I smelled marijuana in your vehicle. Did you recently smell?
No, let me tell you something, man.
Stand right here.
Let me tell you something.
Stand
I don't know. You heard what you said, you smell marijuana, right?
Yeah.
I don't even fucking smoke. So
Okay.
what? But you come with that. That's lip gloss.
Okay.
Okay? This right
Do you
here?
have a medical marijuana card?
No, I don't smoke nothing.
Have you recently smoked hemp?
I don't smoke nothing.
Okay.
So you find that bullshit? That's my money right there for my job.
I got you.
So
I'm
let
not
me
hanging
tell
on
you
to it.
something. You see my back of my shirt? What that show? I show you I'm a barber. You understand what I'm saying? So what you're saying is you smell marijuana. You're alive. So I want to show you something.
Go ahead and unlock the car. Or you can go.
That's cool.
All right, go ahead and sit down in my car for me, okay?
You got my lip gloss and my money?
I got it.
Okay.
Thank you.
Since you smell marijuana,
Yeah, go ahead and sit down.
what's your name?
Officer Oliver, go ahead and sit down for me.
Calvin, sit down for us.
I will. Since you say you smell marijuana.
Sit down,
But
please.
that's the reason you stopped me, or you
It's
stopped me
not the
because
reason I stopped
my
you. For your
light was
lights.
off?
Yes, sir, and
Okay.
you're speeding.
But you know, I was speeding.
Yes.
I got a track on my shit.
Okay.
and you smell marijuana.
Just watch your foot, okay? There's nothing that we can do for the signal 1 portion of it because he refused. I don't know. It smells very strong. This is cologne right here, though. It was like sprayed it like right before. It's got like a gold chain and a bag. Or in a thing. What is this? A ring. Nothing in there. Smell this. It smells like alcohol. Yep. I think we're good on this. Yeah? Okay.
Based off my training and experience.
Okay. It's a hair clip under here. Hey, there's vodka in his seat, like right here in a pouch in his seat. Vodka was found in this pouch in his seat. Huh? And you can just charge him with DWSR.
If you wanted to finish searching, I'll go talk to him about the signal and stuff.
Yeah. Do you need me?
Huh?
Do you need me, like, over there with you?
No.
Huh? Here. Hey, there's vodka in his seat, like right here in a pouch in his seat. Vodka was found in this pouch in his seat. Huh? And you can just charge him with DWSR.
If you wanted to finish searching, I'll go talk to him about the signal and stuff.
Yeah. Do you need me?
Huh?
Do you need me, like, over there with you?
No.
Huh? Here. Okay, I did not find any marijuana.
You're a liar. You're a liar.
Do you want to call your lady?
You're a liar.
Do you
I
want-
can't call nobody my
I can put it in
handcuff.
for you.
I can't call nobody my handcuff.
I can put it in for you.
I can't call nobody my handcuff.
Okay, if you don't let me know the number, then I'm not going to call her, and I'm
You a
going
liar.
to call
you know
a
that.
tow truck
You don't
for
even
your
need to
vehicle.
be on wearing that badge.
Did
You're
you
a
hear me?
liar. You say you smell
Did you hear
marijuana.
me?
You're a liar.
On her own body camera, Officer Oliver just called what she did with that bottle standard protocol. The Supreme Court has spent decades defining what standard means when police destroy evidence before a defendant gets to test it. In California versus Trombetta, the court held that police have a duty to preserve evidence that might help clear a defendant before it's gone for good. 4 years later, in Arizona versus Youngblood, the court narrowed that duty considerably. Destroying potentially useful evidence only violates due process if a defendant can prove the police acted in bad faith. Carelessness or even a real mistake isn't automatically enough. So the seal Oliver broke on Riley's bottle isn't by itself a constitutional violation. It's a question whether what the jury was about to watch looked like bad faith or just looked bad. That question would follow this case all the way to trial.
I'm Officer Kirsten Oliver, Oliver.
Officer Oliver, what's your current position?
I'm a police officer at the Tallahassee Police Department
How long have you been with the Tallahassee Police Department?
since 2020.
So after you stopped the vehicle, where were you, what county were you located in when you stopped this vehicle?
Leon County.
And where was the vehicle located in the roadway when you stopped it?
It was located in the left-hand turn lane.
I want to transition a few minutes forward. So you stopped the vehicle. Do you attempt to make contact with the driver of that vehicle at that point?
I do.
Okay. Can you tell us, as you're walking up to the vehicle, can you tell us what type of vehicle it is up close?
It's a white sedan, and as I get closer, I realize it's a Mercedes.
Were you able to determine who is driving this vehicle?
Yes.
And who was that?
Mr. Calvin Riley.
Do you see the driver of that vehicle in this room here today?
I do.
Can you please identify him by article of clothing?
A black long-sleeve t-shirt.
And let the record reflect that the witness has identified the defendant as the driver of the vehicle. Officer Oliver, do you see any other occupants in the vehicle as you're making contact with the defendant?
No, ma'am.
During this interaction, did you have a body-worn camera on?
I did.
Okay, can you tell us whether or not that body-worn camera was activated during your interaction?
It was.
So, Officer Oliver, on May 7th, 2023, you pulled over a white Mercedes, correct?
Yes.
And you pulled the car over for failure to turn on headlights at night, is that right?
In speeding, yes.
Speeding, okay. And you were wearing a body-worn camera at the time of the incident.
Yes.
When the video comes on, he's already stopped.
No. When the video comes on, I'm still driving.
When you get out of the car, though, your camera is still on, correct?
Yes.
His left blinker was on, is that correct?
I don't remember.
Would viewing your body-worn camera footage from that night refresh your recollection?
Yes.
Are y'all okay with me just playing directly from Axon since I don't have a disc player currently?
No objection.
Okay. After reviewing your body-worn camera footage, did Mr. Riley have his left blinker on?
Yes.
And that's because he got over to the left to stop for the traffic stop, is that correct?
Yes.
And when he got over, he put the car in park?
Yes.
And once Mr. Riley stopped, you approached his left side?
Yes.
When he did not have his license, he gave you his name?
Yes.
He told you it was Calvin Riley?
Yes.
He gave you his date of birth?
Yes.
And that's April 3rd, 1968?
I don't remember from knowledge, but yes.
He gave you his correct birthday,
Yes.
correct? But a switch needed to be turned on to put the lights on, correct?
Correct.
And at some point you went back to your patrol vehicle
Yes.
and you ran his information?
Yes.
Came up with his correct birthday?
Correct.
Came up with his correct address?
Correct.
And that's 429 West Brevard Street?
Correct.
And you believe that he knew that his license was suspended, correct?
Correct.
You believe that's the reason why he didn't have his license?
Correct.
And you checked whether his license was suspended, correct?
Correct.
It confirmed that his address was 429 West Brevard Street.
Correct.
And you testified earlier that notices were sent to that address, is that correct?
Correct.
I am now presenting the witness, which has been pre-marked as State's Exhibit Number 2. Can you please show me where in this it says that it was sent to that address?
So notices are sent to whatever residential address is on there. So the residential address says 429 West Brevard Street.
But you did not mail those notices.
I did not personally know.
So can you show me where it specifically says that those specific notices were sent to that address?
The notices would be sent to residential address.
So you're assuming.
Correct.
So you testified based purely on an assumption.
Correct. On the screen, it stated that the notice was sent and the address that was on the driver's license was 429 West Brevard.
But you did not see an actual mailing address on the notice because you didn't see the notice itself.
Correct.
I'm representing the witness with State Exhibit Number 2. Does this properly reflect what you saw on David?
There is information on this that is also on David.
Okay. But you just assume that something was sent there because that was the residential address.
Correct.
You didn't see something specifically saying, this notice was sent to 429 West Brevard Street.
Not to my knowledge.
Officer Oliver just admitted under oath that she never confirmed where the suspension notices actually went. She assumed. Florida's driving while suspended law is specific about what the state has to prove, not just that a notice existed somewhere in a database, but that Riley actually knew his license was suspended when he got behind the wheel. And Florida's mailed notice statute only goes so far. It says a suspension notice mailed to a driver's last known address constitutes notification, whether or not the person actually received it, but for certain suspensions, including ones triggered by a lapsed insurance policy, the law refuses to presume that mailing alone proves knowledge. Oliver never asked Riley if he knew his license was suspended. She never saw the notice. She checked the screen, saw an address, and decided the rest for herself.
And the bottle was a twist top.
Correct.
When you found the bottle, you took it out of the pouch,
Correct.
and then you put the bottle on the seat,
Yes.
and you continued then to search the car.
Correct.
As part of that search, you opened containers you found in the car, correct?
Correct.
During that search, you didn't find any marijuana.
No.
You didn't find any joints.
No.
You didn't find any paraphernalia.
No.
You didn't find any evidence of marijuana besides the smell.
Correct.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat.
Correct.
And you picked up that bottle.
Yes.
You opened that bottle.
Correct.
That bottle was sealed before you opened it.
Yes.
And so you twisted the top of the bottle
Yes.
and you broke the seal.
Correct.
After you opened it, you dumped out the contents.
Correct.
You dumped it onto the road.
Correct.
Then you put the top back on the bottle.
Yes.
Then you put the bottle back into the car.
Yes.
You threw it on the passenger side.
Yes.
Earlier you said that was just standard protocol.
Correct.
So you usually unseal alcohol bottles and dump them out.
Typically, I don't unseal them, but as I was twisting, I realized it was unopened, and that was my fault.
And has that always been your testimony?
No.
No, but previously you said that you didn't unseal it.
Correct. I didn't believe I did.
But now you know that you did unseal it.
And you told Officer Ruth about the bottle, answer correct. Question, you told her that because she was the primary officer.
And you told her about the bottle because it was evidence.
Correct.
An open liquor bottle found inside the car within reach of the driver would be big evidence for a DUI, right?
Correct.
And you told Officer Muth that the bottle was open?
I don't remember my exact phrasing, but I know that from seeing her report, she said it was opened.
And she would only know that from you.
Correct.
And like you said, she put that in her report.
Correct.
Because the emptied bottle was evidence of DUI.
Can you say that again?
So the empty bottle, that was evidence of DUI at this point, correct?
Correct.
But the contents would really be the evidence of the DUI?
Could be, correct.
But you dumped it out
Correct.
despite it being evidence?
Correct.
Where's the protocol that told you to unseal a liquor bottle and dump it out?
I'm unable to impound liquids into our police department property and evidence. And at that time, I believed I was going to be impounding it, so I dumped it out.
And so what is the authority for impoundment? The rule. Where do you get the protocol rules for impoundment?
Our general orders, and I believe this was General Order 42.
So that would be the standard protocol.
Okay, so you asked where it says not to impound liquid. Wet items would be liquid, so in here it says wet items. Did you want me to read that?
No, like I said, page 8, subsection E.
Okay, you said page 7 through page 8.
Well, it starts in page 7.
Okay, subsection
Can we
E.
re-clarify what the question is? Because I think we're lost as far as what the question is at this point.
I'm trying to figure out where the protocol is to dump out sealed containers of liquid.
Okay, I apologize. I thought the question was, where does it say I cannot impound liquid? And that would be on page 7.
So you can't impound liquid, period. That's what you're saying.
Correct. I cannot impound liquid.
But liquids can be impounded.
Not by a standard patrol officer.
So if you find liquid, you're supposed to notify someone else to come in and pound it,
Correct, in certain circumstances.
if there's evidence.
Correct.
Because you're supposed to impound evidence.
Correct.
And this bottle was evidence, correct?
Correct.
So you should have notified somebody to come in and pound it.
So in certain circumstances, the forensics team would come out, but in a misdemeanor, they do not come out for liquid or for their, I don't know their exact protocols, but I know they don't come out for.
So you just made the
misdemeanors.
decision.
Correct.
Watch what just happened. Oliver's own earlier sworn testimony that she hadn't broken the seal wasn't true, and she only learned that by watching her own body camera. And she just agreed on the record that the bottle was evidence and that she destroyed it anyway. Under Arizona versus Youngblood, that's not automatically unconstitutional. Bad faith has to be proven, not assumed. But Youngblood also asked whether police were following their own established procedure, because a documented policy is exactly the kind of evidence that can prove good faith. Oliver was just handed the Tallahassee Police Department's actual evidence handling policy on the stand and asked to find the part that authorized what she did. She couldn't. Whatever protected her that night wasn't a written rule. It was a decision she made alone in a driveway with the bottle already open.
Yes, Judge. First of all, res judicata is not applicable here because the motion previously filed was a motion to suppress, which goes to the lawfulness of the evidence and the damages that flow from that. This is actually asking you to dismiss, which is a completely different remedy sought. So that's not applicable. The motion to dismiss is based on fundamental due process grounds. Non-waiver of fundamental due process grounds is specifically accounted for in 3.190C. It is timely. With respect to the trial court order, respectfully, a trial management order does not supersede the rules promulgated by Florida Supreme Court. So it is timely. We would ask that it be heard.
All right, I'm going to allow it to be heard. You may proceed.
Thank you. First, Your Honor has a copy of the motion.
I do.
Thank you. There's not a lot of case law that addresses this specific scenario where a police officer essentially manufactures evidence and then plants it.
And that's what you're alleging happened here.
That's what the video shows, Judge.
That's your opinion of what the video shows, but that's what you're alleging happened.
So a full bottle that is sealed is not evidence of a DUI.
Okay.
There's nothing has been drank. A open bottle is evidence of a DUI. And you can see her clearly open it, as you stated during the motion to suppress. A sealed bottle, it's worse than that though, it's a sealed bottle that is open, poured some out, not all, but some, and then thrown back in there. It's worse than that though. After that point, the dishonesty to the other officers about what was found.
I'm not going to sugarcoat it. What you are going to see from the officer is shocking. It is egregious. It is outrageous. It is not an innocent mistake. There is literally an officer on camera making evidence where none existed. And I expect all of you will get to see with your own eyes. Officer Kirsten Oliver of the Tallahassee Police Department stopped Mr. Riley for his headlights being out. She claims she smells marijuana. You will hear Mr. Riley protest. He does not smoke marijuana. The claim that she smells marijuana is what lets her search the vehicle. Officers remove Mr. Riley from his car, put him in a patrol car, and then search his vehicle. They of course find no marijuana, not one bit. And that's for the simple reason that Mr. Riley does not smoke marijuana. However, it is what she does next that is truly shocking. Officer Oliver reaches in Calvin Riley's vehicle, grabs a full, sealed, unopened bottle of liquor, cracked it open. You will actually hear the plastic seal break. It is a distinct sound. You're going to see it from the angle of her own body camera. She was too brazen to even bother turning it off. She then pours out some, but not all of the liquid, puts the cap back on, and then tosses the bottle back into his vehicle. She then lies and tells the officers that she found an open bottle. The evidence will show the police created a crime where none existed.
Before the jury heard a single witness, Riley's own defense attorney asked Judge Jones to throw the entire case out, arguing police conduct was so egregious it violated due process itself. Under Florida law, that's a real doctrine, not just a dramatic phrase. In State v. Glosson, the Florida Supreme Court held that a court can dismiss criminal charges when law enforcement's conduct is so extreme it amounts to a due process violation on its own, independent of anything a jury finds. But Florida courts have set that bar deliberately high, reserved for cases where police effectively invent a crime that didn't otherwise exist, not for cases where officers investigated a real stop and then mishandled what they found along the way. Judge Jones ruled this wasn't that. He sent the question of what actually happened to 12 people who were about to watch the same footage the judge just had and decide it for themselves.
You didn't find any evidence of marijuana besides a smell.
Yes, ma'am.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat,
Yes, ma'am.
and you picked up that bottle.
Yes, ma'am.
You opened that bottle.
Yes, ma'am.
That bottle was sealed before you opened it.
Yes, ma'am.
And so you twisted the top of the bottle,
Yes, ma'am.
and you broke the seal.
Yes, ma'am.
And after you opened it, you dumped out the contents.
Yes, ma'am.
You dumped it onto the road.
Yes, ma'am.
Then you put the top back onto the bottle.
Yes.
And then you put the bottle back into the car.
Yes, ma'am.
You threw it on the passenger side.
I did.
And has that always been your testimony?
Everything that you just asked. I did not know that I opened the bottle in my original testimony.
At a pretrial hearing, you swore to tell the truth, correct?
Yes, ma'am.
And you testified that you didn't unseal it.
Objection, Your Honor.
Overruled.
Yes.
So, at that time, that was a lie.
Unknowingly, yes.
So, Your Honor, I would agree with counsel's argument. However, I would say that at least the state could have still proven under 32203 that as the lesser of the DWS, the defendant's license was not valid at the time. And therefore, we should still be able to go forward on at least that charge.
On a no valid driver's license charge?
Correct.
I'm going to grant the judgment of acquittal based on the statutory provisions and the fact that this was a suspension for a financial responsibility. I'll grant the JOA as to count 2.
That ruling just erased one of the 2 charges against Riley before the jury ever voted, not because of anything the defense argued about the bottle, but because of 4 words buried in a Florida statute. The law that lets a suspended license become a crime normally presumes a driver knew about it once the state proves notice was mailed, but the legislature carved out an exception. That presumption doesn't apply when the suspension was for a lapsed insurance policy, exactly the kind of paperwork violation nobody necessarily notices. The state never found another way to prove Riley actually knew. So the second charge disappeared, not through a verdict, but through a rule written to keep the state from getting a conviction on an assumption alone.
Second, she pulled Mr. Riley
Objection,
over.
inflammatory, and misstatement of the law.
Overruled.
Over and over, from the second she pulled Mr. Riley over until the second she got off that witness stand. Officer Muth lied to you about what she placed Mr. Riley under arrest for, and she lied to her sergeant about what she found in the car. These officers are making things up. These officers are laughing. These officers are asking each other if their cameras are on. These officers are turning off their cameras. These officers are taking an oath to swear to tell the truth And then these officers are lying. They did it right there in front of you. When you apply the law Judge Jones instructs you on, with the conflicts in the evidence and the complete lack of evidence you have seen over these 2 days, it is clear Calvin Riley is not guilty. Officer Oliver opened a bottle of vodka, a bottle that had never been opened before. You hear her break the seal, pour it out, and then put it back in the car. Then she used that evidence against him. She and Officer Muth told their sergeant they found a bunch of alcohol stashed in his car and that the bottle was open. This is simply not true. There is nothing in that cup, which if you watch the video closely, has a lid on it, and the vodka bottle that was opened by Oliver. Members of the jury, these officers want you to believe that they only turned off their cameras because they weren't investigating anymore. Yes, they were.
Like I was saying, this is just a story that the defense has concocted to distract us from the facts and the evidence at hand. Because when the facts are on your side, you argue the facts. When the law is on your side, you argue the law.
Overruled, this is argument.
When the law is on your side, you argue the law. But hey, when neither are on your side, you blame the police. Members of the jury, I want to direct your attention to page 3 in the jury instructions. Starting at the second paragraph. The judge has just instructed us that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or a forced doubt. That line is important to remember. Because what the defense is asking you to believe in this trial is that all of these officers who have never met the defendant before a day in their life decided to get together and connive a plan to frame him in this crime.
In the matter of the state of Florida versus Calvin Riley, case number 2023 CT-854, we, the jury, finds as follows as to count 1 of the information, driving under the influence. The defendant, Calvin Riley, is guilty. So say we all this 8th day of April 2024.
You may be seated. Does either side wish to have the jury polled? State?
No, Your Honor.
Defense?
Yes, Your Honor.
All right, Madam Clerk, can you please poll the jurors? All right, I'm going to adjudicate you guilty as I did before, sentence you to 6 months probation. As a condition of that probation, you'll do 10 days in the Leon County Jail. You'll also have to attend and complete DUI Level 1 school and any counseling as recommended. 50 hours of community service. Your vehicle, if you own one, will be impounded for a period of 10 days. If you no longer own a vehicle, you just need to get a certification from the DHS-MV saying that you no longer own the vehicle, and that can be waived. Your driver's license will be suspended for a period of 6 months. You'll need to attend and complete a victim awareness program. You will have alcohol conditions with random breath test once per month. And your probation can terminate early at the halfway point if you have completed all of your conditions. And Madam Clerk, if you could please announce the standard fines and court costs, and would the defense like them to be itemized?
Yes, Your Honor.
Okay, if you could please break them down for us.
Your Honor, I just want to clarify, was that including cost of prosecution?
She's going to announce them.
Perfect, thank you.
The court cost is $256, the fine is $500.
I accept the responsibility for getting upset and let my emotions get over my judgment of just being a person and staying calm. Like I stated before, I was only going through this emotional stuff because the past I've been through with law enforcement, and what I started going through that night with these officers, it was just a repeat of what I experienced growing up here. And it made me very upset and angry. And if anyone was hurt in that moment, I apologize, but at the same time I was hurt too. And I'm still dealing with it. And that police that the state is talking about, I was unaware of that until like they came on board. I have a new lawyer. All this stuff was brought to my attention last month, and things started changing. So I don't have time to process all this stuff neither. I don't know what else to say.
The jury convicted Calvin Riley of driving under the influence. The charge of driving on a suspended license never reached them at all. Judge Jones had already thrown it out days earlier on the statute's own terms. 10 days in jail, 6 months of probation, a license suspended for 6 more months, fines and court costs that ran well past $1,000. None of that turned on the bottle Kirsten Oliver poured out. The state told the jury more than once that the bottle wasn't evidence in this trial at all. The conviction rested on 15 other signs of impairment, on Riley's own words and his own driving that night, which leaves the actual question this case raised unresolved, not whether Riley was impaired, but what happens the next time an officer breaks the seal on evidence and the only account of what was inside it is her own. The Constitution doesn't promise that police get it right. It promises that when they hold evidence that might help a defendant, they don't get to decide alone, and without him, what happens to it before he ever sees it. Calvin Riley wasn't convicted because of the bottle Oliver destroyed. He was convicted despite it, which either proves the system corrects for a mistake like hers or proves it never needed the bottle to begin with. So which